Justice Kagan?
Mr. Hurst, I want to take you back to our conversation about whether there's such a thing as applied equal protection challenges, and ask you for two things. The first is I do think that runs counter to a couple of things that we think of as basic principles of constitutional law and maybe equal protection law particularly. In constitutional law, we often say as applied challenges are the preferred mode of constitutional adjudication. Certainly, we have not erected like bars to them in any other area, as far as I understand it. And then in equal protection law, we say all the time things like people need to be treated as individuals and not as just as members of a group. And I'm wondering whether both of those principles don't suggest that any bar on equal protection, as applied equal protection challenges, is just wrong, is off. And then the second thing I want you to do after you do that is assume for me that there is such a thing. Okay. And to tell me how, in your view, an as-applied equal protection challenge ought to work in this case.
Certainly, Your Honor. The first answer would be, I recognize those principles that Your Honor is alluding to. The contrary principle would be the very nature of intermediate scrutiny analysis, that it is always possible, if you only have a substantial fit supporting legislation, then it is always possible to find people whom it doesn't fit, and then we're in strict scrutiny.
So I completely take that point, Mr. Hurst. I mean, you're exactly right, and of course, intermediate scrutiny is different from strict scrutiny. It doesn't require the, almost perfection that strict scrutiny does. Completely take the point, but isn't that point really addressed to what we often consider in these areas, which is to facial challenges, right? So when you bring a facial challenge, of course, that's right, that you're allowed to have over-inclusiveness and under-inclusiveness and a lack of a perfect fit, but that the nature of an as-applied challenge is different.
Certainly the court could do that, Your Honor. The court has not done that before, as I think we both agree. And the result of that would be judge-made exceptions to laws anytime judges thought they didn't make sense for particular classes of plaintiffs. And the deference to the legislature that should exist to some degree, even under intermediate scrutiny, would be done away with. It would be gone. And then the administrability justification for many sex-based classifications, including this one, would also be gone, because you could no longer administer the classification evenly. You would have to make as many exceptions as courts thought you needed to make. So it's really an institutional competence thing or institutional power thing between courts and legislature.
So you're suggesting to me that the whole thing is just unworkable and we shouldn't, but flip to the second prong of my question, which is suppose we said, where as applied equal protection challenges exist as applied anything challenges do. What would it look like, do you think? What should it look like?
Yeah. I'm not sure what it should look like. I can say what it does look like in this case and why we think there's a problem with it.
So you're not willing to take me on my second path, which is like, let's assume that there is such a thing as this challenge.
Yes. I mean, the most I can say, I doubt this is a satisfactory answer, Your Honor, but the most I can say is that the as-applied nature of a challenge might go to the remedy. The legal analysis still focuses on the classification and the justification for the classification. And once we're talking about individuals, we're not talking about a classification anymore.
Yeah, I mean, that doesn't seem like much of an as-applied challenge, right? You have to prove the exact same thing as you do in a facial challenge, but don't worry because you only get relief as to you. So that's not a true as-applied challenge.
And I'm having trouble coming up with what it could look like, because it will always be possible to carve the class down further, right? I mean, so if they say that their class, that their subclass, I guess, subclass of males, is males who identify as transgender, then we would come back and say, well, only something like 10% of males who identify as transgender take the testosterone suppression. And then they might say, well, okay, no, the class is just the males who take the testosterone suppression. And then we might come back and say, well, according to the record, according to their own expert, of males who take testosterone suppression, only 1/4 of them are able to achieve the appropriate, achieve ordinary levels of testosterone for women. And the other 3/4 would still have an advantage, and therefore we'd be justified 75% pretty good fit in intermediate scrutiny, and we'd be justified with the law. But then they can just change the class again. They can say, aha, no, our class is males who identify as transgender, who suppress their testosterone, and who suppress their testosterone successfully and are able to get it down to where they don't have a competitive advantage. And at that point, we can say, if you can define the class so precisely, you're going to force the state to define the class that precisely. It's going to be enormously burdensome for everyone, and the state can never win, because whenever the state points to the fit in the statute, they just redefine their class as only the people who are outside the fit.
Thank you.